Hello viewers, today I will talk about arbitration. Disputes and differences are inevitable in a human society, and we need definitely the solution of it, how they can be resolved. And one must go to court for resolution of any dispute or difference. Courts, as we know, are independent and impartial authority which impart justice to citizens. Courts, proceedings, delays, yes, and particularly in our country, they are proverbial. Each court often takes a decade to decide the case, and ordinarily, citizens will not be able to bear with this time. In this situation, what is the alternative? And the legally recognized alternative is arbitration. What is arbitration? Just in few words, I will tell you that decision by a chosen man. How this can happen? That is provided in the Arbitration and Conciliation Act 1996. Since this is meant for general information, I would not refer to intricacies of law, nor the provisions of law, nor minute details of the Act. Broadly, what is arbitration? How proceedings can be conducted? And how they are beneficial to the parties who are at difference. Friends, arbitration is the only exception, so to say, whereby instead of going to the court, you can go to some independent, impartial person of your own choice. And as the Act says, no qualifications as such are prescribed of an arbitrator. So any person in whom one reposes confidence, has a faith, yes, can be appointed as an arbitrator. As the saying goes, justice by wise, wealthy and old men can be used very well in arbitration. The present law by which the arbitration is governed, I may make a reference just to inform you, that is based on international treaty known as UNCITRAL, United Nations Commission on International Trade Law, which has drafted modern arbitration law. And the present Act is based on that drafted model law. Why I am making reference of this? To remove any doubts that our law may be deficient in certain respects, and therefore parties ultimately may suffer. That is the often feeling of the parties. And to dispel that, I am making this reference that the present law is based on international treaty. Now, first of all, how this arbitration can be had. Law requires that there has to be arbitration agreement between the parties. That agreement must be in writing, and the Arbitration Act itself defines the arbitration agreement and even a document which is referred in the agreement, and that document has an arbitration clause, the Act treats such as an arbitration agreement. So the definition of arbitration agreement is very wide. But one thing is certain, that it has to be in writing. There cannot be oral arbitration agreement. And obviously this is meant to be taking away the jurisdiction of the regular court. And therefore it has to be in writing. Once the arbitration agreement is there, the law gives freedom to the parties. And freedom to what extent? I must say it will be beyond your imagination. The parties are free even to agree to procedure for appointing the arbitrator. It is only in case where it is not materialized you can go to court for appointment of arbitrator. So far as number of arbitrator is concerned, again, law gives freedom to the parties to have any number of arbitrators. And in absence of any number, it would be the sole arbitration. As I have told you, no qualifications are required. Persons of your faith, confidence can be appointed as an arbitrator. After appointment of arbitrator, certain duties are cast even on the arbitrator. The foremost duty is that an arbitrator is under obligation to disclose any circumstances which would give justifiable doubts as to his independence or impartiality. Further, the arbitrator is under obligation to treat the parties equally. If there are justifiable grounds that can be challenged, and procedure is prescribed for that. The procedure of arbitration, again, law has given maximum freedom to the parties. I may here mention that there is express bar of applicability of Civil Procedure Code and Evidence Act to the arbitration proceedings. Meaning thereby, the conduct of the arbitration proceedings is not bound by the rules of Civil Procedure Code and Evidence Act. Substantial freedom is given to the proceedings. And as we know, rules of procedure are very strict and often they create delay. Therefore, they are not made applicable to the arbitration proceedings. And parties are given freedom to agree to procedure, meaning thereby how arbitration proceedings shall be conducted. That also can be agreed by the parties. And in absence of such agreement, the arbitrator himself may fix the procedure. Having fixed this procedure, the exchange of statement of claim and written statement within stipulated time is to be done. Parties may even agree that oral evidence may not be adduced, and whatever parties have to submit, they can submit. what shall be the language of arbitration? That is also left to the parties, and they can decide in which language proceedings shall be conducted. Even the place of arbitration is left to the discretion of the parties, meaning thereby parties can decide as to where the arbitration proceedings shall be conducted. In short, I can say that you can go to a man of your choice, tell him that, sir, we will appoint you as an arbitrator if you are prepared to pass an award within a week or fortnight, having placed in Ahmedabad. We proceed with the arbitration. And yes, it can be done under this act. So far as the arbitration agreement is concerned, it is absolutely free in the sense that Arbitration Act provides that no judicial authority shall intervene in the proceedings except provided in the Arbitration Act. And very few circumstances are there where court will intervene. Even the arbitrator is given powers to pass an interim order for protection of the property in dispute, for preservation, etc. So, just as you can go to the court and ask for interim relief, equally you can go to arbitrator and pray for such relief. Therefore, arbitrator is equipped practically with all authorities for deciding the dispute and preserving the property in dispute, so that no injustice is caused to any party. Having done so, the arbitrator has to pass the award, and that award, under the provisions of the Act, is treated as final except where the arbitration award is challenged under Section 34 of the Act, or in a given case appeal is preferred under Section 37 of the Arbitration Act. And once the arbitration award is final, it can be straightaway enforced as if it is the decree of the civil court. Pausing here for a moment, I may tell you about two things. Setting aside an application for award, Section 34, which provides certain grounds like incapacity of the parties, not giving the opportunity, etc. There are very limited grounds on which application can be made to the court for setting aside an award. Grounds are so limited that ordinarily courts would be slow in setting aside the award. The moment application for setting aside is rejected, the appeal can be preferred against that, and subject to the decision of the appeal, the award becomes final. Now, appeal is also on a very limited ground. Section 37 provides appeals only in limited cases, and when award itself cannot be challenged on the grounds except the grounds stated in the Act, obviously appeal also stands to such limitations. Thus, it is very clear that the arbitration proceedings, yes, can be the fastest remedy. often, yes, one can say that experience is otherwise. Even after the award is passed, parties litigate under section 33, under section 34 and then 37. But then the scope of the litigation in this section is very limited. Just one more thing. Section 33 speaks of correction of the award. If there are some clerical mistakes or some mistake in calculation, yes, within the stipulated time, application can be made for correction of such mistakes and not more. And therefore, you can visualize that protection is given to the arbitration proceedings from all aspects in order to see that they can be fastest. The provision is also made to the extent that when there is arbitration agreement and despite that the other party goes to the court may send the same party to the arbitration, and meanwhile, very interesting, the arbitration proceedings are not stayed. On the contrary, it has been expressly stated that arbitration proceedings may be initiated, continued, and award may be passed. So, once there is arbitration agreement, party is fully protected, and ordinarily there will not be any intervention from the civil court.